Okay, my name's James and today we're going to be talking about gifts and trusts. Now, in order to succeed in your exam, one of the things to remember is that it's not just a simple matter of knowing what the law is, but it will also help you to know why the law is the way it is. In terms of thinking why the law is the way it is and why we need a set of rules governing gifts and trusts, we need to think for a moment about the possible disputes that could arise in the case of a gift. So for instance, a man gives a gift of a car to his mistress and then later changes his mind. The mistress actually thinks, hey, I actually quite like this BMW and I don't want to give it back. In a situation such as this, the law needs some kind of system or procedure to decide who keeps the car. Does the mistress keep the BMW or does the boyfriend get to take it back? Now, what I'm going to do now is move away from this issue of having some thought as to why the law is the way it is, and instead we're now going to look at the use of checklists. And I'm going to give you a brief overview of a checklist that you will take with you into your trust exams. Now, in terms of checklists, what you need is something clear and simple. And this is the one I recommend whenever you are dealing with a gift and trust question. So, number 1, capacity. 2, 3 certainties. 3, the beneficiary principle. 4, the issue of perpetuities. 5, formalities. And finally 6, constitution. So that's a list you take with you into your exam. You write it on your exam paper and make sure that when you answer that trust question, each of those issues are addressed. Okay, now I'm going to explore each of these in more detail. And I want to emphasise here, I'm talking about the College of Law Open University syllabus. Some of you may be studying at different universities, so I add that caveat. This is the course subject matter I will be commenting on. Okay, let's start with capacity. This is a fairly straightforward issue. It's just generally, in terms of the settler, are they over the age of 18 and of sound mind? In the exam questions I've looked at, this has never been a significant issue. Now we're going to look at the age 2 on the checklist, which is the 3 certainties. The 3 certainties necessary in order to establish a trust. And these are certainty of intention, subject matter and object. I'm going to give a very brief overview of what you need to look at here. Certainty of intention. Basically, you need to ensure that the content of the trust declaration contains wording that clearly indicates an intention by the settler to transfer subject matter to trustees to hold for the benefit of identified beneficiaries. So, in terms of intention, you're looking for words like, I instruct so-and-so to hold on trust for persons X, Y and Z. In terms of subject matter, there are 2 issues that are going to come up. One is where a smaller amount of a larger holding has been identified as the subject matter of the trust. You need to be aware that there's going to be different rules for shares, chattels and money. And the third certainty is certainty of object, and the certainty of object test you need to use will depend on the type of gratuitous transfer arrangement in question. So whether that's a fixed trust, a discretionary trust, and this strange hybrid of gift and trust, the gift subject to a condition precedent. Okay, now we're going to look at the beneficiary principle. Put simply, a trust must have beneficiaries who the court can decree performance in favour of. The beneficiary principle is only really an issue where the trust is a purpose trust. Stage 4 on our checklist is perpetuities, Thinking back to what I said earlier about why is the law the way it is, well, put simply, the law does not want to see money tied up for indefinite periods of time and for perhaps meaningless trust with no beneficiaries to go on forever. So if we're looking at a people trust, we need to make sure that the trust does not offend the rule against remoteness of vesting, and that only really is an issue where the trust is creating a contingent interest. If it's a purpose trust, we need to ensure it doesn't offend against the rule against inalienability of capital. Generally speaking, we need to ensure that the trust purpose will be fulfilled within 21 years. Stage 5, formalities. Now, the 3 formalities on offer are an oral declaration, signed writing, or witness signed writing. And those are the 3 things you need to have in mind. General rule is a declaration of trust can be oral unless the subject matter is land, in which case the declaration must be in signed writing, or if the subject matter is a disposition of an existing equitable interest, then again it must be in signed writing. Finally, we're going to look at stage 6 on our checklist, which is constitution of the trust. And what we're looking at here is whether there has been an effective transfer of subject matter from the settlor to the trustees. Now, there are 2 stages to examining whether the transfer has been effective. Firstly, we need to identify the subject matter and say, for instance, is it shares, is it land, is it chattels? And once we've identified the subject matter, we need to ask one of 2 questions. Firstly, has the settlor done enough to effectively transfer legal title to the trustees? And failing that, has the settlor done enough to effectively transfer the subject matter so that equity regards the transfer as complete under the every effort test? So let's take the subject matter of shares, and in order to effect the transfer of legal title, the settlor will need to deliver signed stock transfer form and the share certificates to the trustees. The trustees will then need to register the shares at the company, so the name of the settlor is replaced by the name of the trustees on the company's register of members. But let's imagine that this transfer of legal title didn't happen because at some stage maybe that the settlor died or he changed his mind. At what stage will equity regard the transfer as complete under the every effort test mentioned in cases like Milroy and Lord and in the matter of shares in Wee Rose? So, equity will regard the transfer as complete once the settlor has delivered the signed stock transfer form and the share certificates to the trustees. If, heaven forbid, the settlor is run over by a bus, then the courts will regard the transfer to trustees as being complete at that stage. So, to summarise our 6-point checklist that we're going to take with us into the exam so that we have a clear structure to tackle any trust or gift question we may come across is, number 1, we look at settlor capacity. 2, does the declaration of trust comply with the 3 certainties? 3, does the trust offend the beneficiary principle? 4, does it offend the perpetuity rules? 5, does the declaration of trust meet with the formality requirements? And generally the 2 options are going to be oral declaration or signed writing. And finally, number 6, has whatever the subject matter of the trust may be been effectively transferred to the trustees? Okay, I hope you will find my checklist to be of assistance to you when you come to do your trust exams. Finally, I'm available for private tuition at the price is listed in my advert, and if you need more details, contact me on the email listed or on the telephone number listed. Thank you very much.